Shall clause 46 carry?
That's one that I have an amendment to propose. So, on that, I propose to clause 6, pages 21 and 22, that Bill S4 be amended in clause 46A on page 21 by deleting lines 4 to 16, and on page 22 by replacing line 5 with the following, quote, means, comma, other than a trial for a summary conviction or indictable offense, comma, the court may allow the accused or offender to, quote.
Senator, can you hold for a second?
Yes.
Just want to make sure everybody has the amendments. Do everybody have the amendments? Yes. Okay. Sorry.
So, thank you. So on this particular one, honorable senators, given the substantial evidence we have heard at the Senate Legal Committee, I'm proposing this particular amendment to Bill S4 to remove the portions of Bill S4 which would allow the accused to appear and testify at their criminal trials by video conference. And under this act, all criminal trials, despite their severity, could be held this way, other than jury trials. Both summary and indictable trials could be conducted this way. I submit that for criminal trials, where the credibility of the accused is almost always a major issue to be determined by the judge, video evidence is not sufficient. There can be many different technical reasons, but I submit that a vast problem with this is the issue of credibility. And I am certainly not proposing that all video conference ability for the accused be taken out. That's something that's dealt with in several sections in this particular bill. It would still be allowed under my amendment for other types of criminal court proceedings and appearances, including bail, preliminary inquiries, pleas, sentencing, and other types of proceedings. Only trials would be removed from this. And in addition to the credibility concerns, I thought we actually had some very helpful evidence that came forward from a number of witnesses that we had at our meetings. And a few of them I want to just reference because they brought a very important, different perspective on this. I will start with Emily Coyle, the executive director of the Canadian Association of Elizabeth Fry Societies. When she testified partly dealing with the issue of stigma for an accused. And when I had an opportunity to question her, I said to her, I'm concerned about how Bill S4 allows an accused person to testify by video at summary offense trials. Of course, I now know it's also indictable. And I think your opening remarks, and you also expanded on it a little bit just recently here, provided us with some really important context on that issue about the stigmatization that can exist for an accused testifying from jail. Because what can happen, it can cement in the trier of fact's mind, in this case the judge, that someone being seen in a jail setting during a trial should perhaps remain in jail and potentially give a bias to a guilty verdict. And Ms. Coyle responded by saying, thank you, I'm grateful for that question, Senator, and I think that stigma aspect I spoke about is really something that we don't consider when we're talking about video conferencing. Again, what I said at the outset was that our society assigns judgment to people who are in prison without understanding their background. She went on to say, because we have this idea that people in prison are bad, we put bad people in prison, that judgment that we cast upon people who are in prison would lead potentially to an outcome in a trial that would not necessarily have been the outcome had that person not been in prison. Maybe they would be able to put on a suit that their family had given them. Maybe their family would be sitting behind them in the courtroom. Just those subtle differences influence our bias. And then when I was questioning Mr. Knox, who was from the Canadian Council of Criminal Defense Lawyers, I proposed to him the possibility of an amendment about taking the ability to have summary offense trials, and of course, indictable trials by video out of Bill S4 and leaving the other types of court proceedings in it. And Mr. Knox responded, I agree with you. If we do back away from this pure model that's been developed over 150 years, there are places that we could start to see how it works. Then as well, Ms. Tash Green also testified at that particular proceeding from Nunavut Legal Aid. And you will recall that we had some significant difficulties with her ability to actually testify in front of us at our committee. And so I said to her, in your opening statement, you talked about how you were urging caution, and you provided us some really important points of view, both in what you said And then in how your testimony actually came out. First of all, you talked about how 24 out of 25 communities in Nunavut don't have technology to do a video conference in court, which is quite alarming. Then partway through your testimony, your face froze and it came through for us saying network bandwidth is low. And that's when the chair wisely asked you to turn off your video so we could still hear you. And we did hear you well with the audio alone. You're in this particular position working in a legal aid office, I imagine, with some generally decent connectivity, and probably a lot of the clients would not have had that sort of thing. I'm wondering if you could comment a bit more on that. Then I said to her, I went on to say, I'm quite concerned about having video trials where the accused would potentially be subject to these types of situations. I'm wondering what you think about the possibility of, rather than using video for a summary trial, instead of using video if it's to proceed, with having video for a number of different court appearances like bail, guilty plea, sentencing, and things that are generally briefer than a full-on trial before having that. What do you think about that possibility? And Ms. Tash Green from Nunavut Legal Aid responded, I am very interested in your comments about perhaps holding off on making video conferencing available for trials and starting with proceedings that have lesser jeopardy. She went on to say, I'm very concerned about the possibility of trials proceeding with an accused who is, of course, the person with the most at stake, being potentially cut out of the proceedings by the technology breaking down. So we had a number of different reasons that showed that perhaps the best place to start when we're expanding our ability to have technology on such critical matters as trials, perhaps we should simply start with these matters of lesser jeopardy, as Ms. Tash Green put it, and deal with things like pleas, bail, preliminary inquiries, sentencing. All of these things would be allowed to have video conferencing, but simply not trials under the amendment that I'm proposing.